Hi everyone. I wanted to say thank you to all of you who tuned in to Alankriti Sethi's and my recent webinar in relation to the management of force majeure claims. Thank you all for your attention, your engagement, but most importantly for the excellent feedback that you provided us. A number of you came back with specific questions, and a number of you asked us to deal with, having gotten the theory out of the way, certain examples, live scenarios of force majeure cases that we've dealt with. And so we thought, as a part of this thank you note, we'd embed a few quick war stories that we can share with you to give you an insight into how we've implemented the learnings that we shared with you at our last webinar. And so with that, and with your permission, allow me to delve into two distinct fact scenarios that'll give you an insight in applying the learnings that we've discussed. Before we get into the fact scenarios that I'll deal with, let's for a moment reflect upon the big takeaways from our last session. When Alankriti and I led our last session, we explained to you that the textbook, the classical manner of managing a force majeure claim is to firstly, when confronted with a claim of force majeure or when defending a claim of force majeure, refer to your contract. Determine whether there's a force majeure clause in that contract. If the answer is in the affirmative, read the clause and determine whether or not the event that you're confronted with, the real life event that you're confronted with, is an event of force majeure as defined under that clause. If the answer to that is in the affirmative, examine whether or not there is a causal link between the occurrence of the event and your or your client's prevention and performance. Now, there are a couple of other steps, such as the collection of evidence and the management of communications, etc., which we'll deal with. But for the purposes of this first fact scenario, let's just walk you through how these three steps can be implemented in real life in responding to a claim of force majeure. In the first case that we'll discuss today, our client was a seller of commodities pursuant to a long-term contract. The contract was subject to the FOB Incoterms. So our client was an FOB seller, their counterparty was an FOB buyer. And the claim arose at the height of the global pandemic. Obviously, prices had fallen. The buyer was not keen on taking delivery of the goods and was looking for any methodology to avoid its obligations. And so what they came up with was this. The buyer declared force majeure on account of its inability to discharge the goods at the discharge port because of movement restrictions at the discharge port. So let's say hypothetically the buyer was located in India. India was in the midst of lockdown. Personnel could not access the port, the vessel could not berth, etc., etc. And so on account of the pandemic restrictions, the buyer declared force majeure. They issued a notice of force majeure. When our client came to us, they were obviously keen to ensure that their counterparty would perform. And so they asked us to examine whether or not the declaration of force majeure by the buyer was a valid declaration. And so in responding to the client, we followed exactly the steps that Alankriti and I explained to you in the last episode of this webinar series. We examined the contract. We determined that there was in fact a force majeure clause in the contract. Having determined that, we ascertained that pandemics were defined as an event of force majeure under that contract. Now, it was the opponent's position, the buyer's position, that it was unable to perform on account of the global pandemic. Ergo, it was the buyer's position that there was a causal link between its inability to perform and the event that was defined as an event of force majeure. So if you recall the methodology that Alankriti and I prescribed for you, it would seem that this was a valid declaration of force majeure. There was a contract that included a force majeure provision. The force majeure provision defined the pandemic as an event of force majeure. And according to the opponent, it was the pandemic that was preventing them from performing their obligations under the contract. Seems like a valid declaration of force majeure. However, ladies and gentlemen, you might recall that I had at the outset, when describing the facts, said this contract was subject to the FOB Incoterm. Our client was an FOB seller, and their counterparty was an FOB buyer. Now, those of you that are familiar with international trade will know that under an FOB contract, the seller's obligation is to deliver the goods to the buyer at the load port. Once the goods are loaded on board the carrying vessel at the load port, the seller's obligations cease. The buyer is then required to ship the goods to the discharge port, but that is not subject to this contract. Those are the buyer's independent obligations. There were no movement restrictions at the load port, and our client, the seller, was perfectly capable of loading the goods onto a carrying vessel at the load port. Similarly, the buyer was perfectly capable of bringing in a carrying vessel to the load port and loading the cargo there. Therefore, there was in fact no causal link between the pandemic and the buyer's inability to perform. In fact, the buyer was perfectly able to perform. And that is exactly the position that we adopted with the buyer. We said to the buyer, as an FOB buyer, your obligations are at the load port in relation to delivery, not at the discharge port. Accordingly, any restrictions at the discharge port are entirely irrelevant for the purposes of this contract. And I'm pleased to inform this audience that that buyer then withdrew its claim of force majeure and was constrained to perform its obligations under the contract in due course. With that first scenario out of the way, I'd like to get into the second case that we wanted to share with you. You might recall when Alankriti and I talked about the theoretical approach to the management of force majeure claims. With the contractual reviews out of the way, we advised you to engage in an evidentiary exercise for the collection of evidence demonstrating the causal link between the occurrence of the event and the prevention and performance. This example that I'm going to now walk you through deals with that evidence collecting exercise and the potentially far-reaching implications of such an exercise. Now, the case that we were confronted with arose out of wildfires in the Canadian countryside, which had caused our client's production facility to have its connections to the port severed on account of these wildfires. Our clients had a facility that was connected to the port via road and rail link. They traditionally moved cargo via rail, and the rail link was severed by these wildfires. Now, when instructed by the client, we went through the usual steps that we've already talked about. We examined the contract. We determined that the contract had a force majeure clause. Wildfires were specifically enumerated as an event of force majeure under that clause. And our client's instructions were that, Sumit, we can't get the cargo to the port because the rail line has been severed. So again, ostensibly, it looked like our clients were perfectly entitled to declare force majeure. Now, however, when we commenced the evidence gathering exercise to determine whether or not, in fact, our clients were prevented in their performance, we uncovered that the laycan commenced on the 11th of the month, say hypothetically. Our clients were well aware, they run a very sophisticated operation, and though they had an obligation to load something like 180 odd thousand tons of cargo on board the carrying vessel, they knew that the vessel was unable to load more than 40 to 50 odd thousand tons per day pro rata. And therefore, they would only move cargo on a just-in-time basis to the port facility. The laycan commenced on the 11th. On the 12th, the rail line was severed. As of the 11th, the clients had 60 to 80 odd thousand tons of cargo lying at the port, and they reassured me. They said, Sumit, we always have cargo at our production facility. It takes less than a day to move it to the load port. And had the fire not severed the rail line, we would have continued to move cargo to the load port for the loading on board the vessel in a progressive manner over the course of the next few days. But we were prevented in our performance by the occurrence of the fire. And therefore, our clients were insistent that they could declare force majeure. However, unfortunately, the advice that we had to give our clients was that, look, in your capacity as a charterer of ocean-going tonnage, your obligation is to have a full and complete cargo ready for loading at the load port on the date of commencement of the laycan. Your obligation, therefore, was to have 180,000 tons of cargo ready to load at the load port on the 11th. For reasons of operational convenience or for reasons of cost, you chose only to have smaller lots of cargo available at the load port. And you're entitled to do that. However, nothing prevented you from transferring the full 180,000 tons to the port before the 11th or on the 11th. You didn't do that. The proximate cause, therefore, of your inability to have a full and complete cargo at the load port is your decision to load in a progressive manner rather than the fire that severed the rail link. And so this, for me, illustrates the far-reaching implications of that evidence-gathering exercise. And look, it's as I said during the webinar that we delivered to you last week, when confronted with the claim of force majeure, chances are you're in a panic. It's a high stress situation. You need to respond rapidly. But any good lawyer will tell you that no, you need to slow down and you need to collect that evidence, because had our client in this case recklessly issued a notice of force majeure and then started collecting the evidence, they would have found themselves in a situation where they had invalidly declared force majeure. They'd be faced with a claim for damages. You want to make sure that you avoid that. And so I'd caution that when confronted with a claim of this nature, notwithstanding the pressures that you are subject to take a step back, to follow the steps that we've described. And please do not hesitate to reach out if you need our assistance for the management of claims of this nature. Ladies and gentlemen, thank you again for all of your attention. If you've got any questions at all about this topic, you know where we live, please get in touch. Thank you again.